Supreme Court of India K.P. Tamilmaran vs. the State by Deputy Superintendent of Police decided on April 28, 2025 0 NSC 576. Facts of the case: Kannagi and Murugesan were in love. The two got secretly married before the registrar of marriage. Murugesan and Kannagi were killed. Both of them were administered poison in full view of a large number of villagers. The reason behind the murder of this young couple was that Kannagi, belonging to the Veneer community, had dared to marry Murugesan, who was a Dalit from the same village. Dalit community raised this issue through press and media, and as support was gathered from the public, that a case was finally registered on July 17, 2003 under sections 147, 302, 201 of IPC at police station. On May 21, 2004, the CBI again registered its FIR under sections 147, 302, 201 of IPC. A total of 15 accused had faced trial. Accused number 1 to accused number 3, accused number 5 to accused number 8, accused number 10 to accused number 13 were convicted primarily under sections 302 read with 149 of the Indian Penal Code. Accused number 4 and accused number 9 were acquitted by the trial court, while accused number 3 and accused number 13 were acquitted by the High Court. The 11 accused who stood convicted and sentenced by the High Court filed the appeal. Findings of the court: the phrase hostile witness has come to be used for a witness who gives a statement contrary to the story of the side for which she is a witness. All the same, because a witness has supported some, though not all, aspects of a case, it would not automatically mean that this witness has to be declared hostile. A party can cross-examine its own witness under Section 154 Evidence Act, even without getting a declaration of hostility. The only restriction to cross-examination under Section 154 Evidence Act is that the party, who seeks to cross-examine its own witness, must obtain the leave of the court. Whether there is a declaration of hostility or not, one thing is clear: that evidence of witness, who has been cross-examined under Section 154 Evidence Act by the party who called such witness, cannot be washed off entirely, and it is for the court to see what can be retrieved from such evidence. If part of the evidence of a hostile witness corroborates with other reliable evidence, then that part of the evidence is admissible. Once a prosecution witness has been declared hostile and then cross-examined by the prosecution, then it is for the court to evaluate the veracity of the testimony. The benefit of such witnesses turning hostile cannot be given to other accused who were found involved in the offense. On the overwhelming weight of other evidence, the benefit of such witnesses turning hostile cannot be given to other accused who were found involved in the offense. On the overwhelming weight of other evidence, in the present case, prosecution witness 49 did not support the case of prosecution on some aspects, such as the role of accused number 4 and accused number 9, Dalits who were made accused, yet her evidence in respect of other accused was correctly relied upon by the trial court in convicting the other accused number 14, K.P. Tamilmaran, and accused number 15, M. Selamuthu. Both had committed the offenses under Section 217 IPC and Section 4 of the SC/ST Act as they neglected their duties and disobeyed the law by not registering the FIR at the first instance with the intention to save the culprits. The role of accused number 15. Like accused number 14, accused number 15 too is guilty of offenses under Section 217 of the IPC and under Section 4 of the SC/ST Act, but, in addition to these wrongdoings, it is also borne out from the record that it was accused number 15 who was the main architect behind the FIR dated 17 July 2003, which falsely implicated the 4 members of Schedule Caste community. Further, it was accused number 15 who was in charge of the investigation which led to the filing of the charge sheet against the innocent persons belonging to Dalit community. There is no doubt that A.15 did this entire exercise to absolve culprits belonging to the Veneer community of their complicity in the crime, and he knowingly and deliberately falsely implicated some of the Dalits in an offense punishable with death. Evidence, as discussed earlier, makes it clear that accused number 15 manufactured the extrajudicial confessions and evidence and thereafter filed the charge sheet against Dalits on the basis of that evidence. Hence, the High Court rightly upheld the conviction of accused number 15 under Sections 217, 218 of IPC and Sections 4, 3, 2I of the SC/ST Act and a sentence of life imprisonment. There is no doubt in our mind that accused number 15 is guilty of the offenses as held both by the trial court as well as the High Court in appeal. A crime is an act against the state, but a wicked and odious crime, as the one we have just dealt with, is the ugly reality of our deeply entrenched caste structure. Honor killing, as these are called, must get a strong measure of punishment. We are also of the opinion that victim compensation here is warranted. We thus award compensation of Rs 5 lakhs to prosecution witness 1, Samakana father of Murugesan, and prosecution witness 49, Chinnapillai, stepmother of Murugesan, jointly, or to the nearest of their kins. Appeal is dismissed.